We're going to turn now to a discussion about a couple of financial matters, one in particular dealing with your IRAs, and a specific type of an IRA called an inherited IRA. So let's talk a little bit, Gerry, about what an inherited IRA is and a recent unanimous Supreme Court decision that came out that impacted how those are distributed.
Let me ask you a question. How many of you have an IRA? Almost everybody, large bunch of you. Let me tell you a little bit about what happened back in 2005. President Bush signed what was called the Bankruptcy, Abuse Prevention and Consumer Protection Act, the BAP-CPA. And the intent of that was Congress said, you've worked hard to provide for your own retirement. You've put money aside, you've sacrificed. We don't want to deprive you of that. So if you have an IRA, we're going to protect it. It cannot be taken in a bankruptcy, cannot be taken in a lawsuit, cannot be taken in a divorce. I mean, they really wired it in. They said, we're going to protect that IRA. And at the time, that applied to an inherited IRA. Now, Larry will probably go into more detail on this, but an inherited IRA isn't a spousal IRA. It's an IRA that you leave to your children or to somebody other than a spouse. Okay? Well, what happened is primarily the credit card companies didn't like that because there's lots of money in IRAs. And if someone defaulted on a credit card, they wanted to be able to get to that IRA account to recover the money. And they kept bringing lawsuits and they kept losing, they kept losing, they kept losing. And then they changed their tactics. And they said, okay, we can't go after the IRA, but we can go after inherited IRAs. And the U.S. Supreme Court, in the case of Clark versus Ramaker, agreed with them. The U.S. Supreme Court said, well, an inherited IRA really isn't a protected IRA because the kids didn't work hard and sacrifice to put this money aside. You did. And the kids can't add money to it to build for their own retirement. And they have the right to take the money out immediately. So we're going to take away all that protection for inherited IRAs. Which means if you die and you leave your IRA to your son and his wife files for divorce, she could wind up with the IRA. If he has to file for bankruptcy, the bankruptcy court can get the IRA. If he has a lawsuit in an automobile accident, they can take the IRA. The problem is a lot of financial companies over the years have said, don't name your trust as the beneficiary. Name your spouse first, your children second, because that'll benefit them. Well, if you did that, you've just taken away all of their protection. Now, the good news is there is a way to protect it. If you have a more recent trust, and if that trust has, and you won't know whether you have this or not probably, but if it has family retirement protection language in it, and if you name the children within the trust as a beneficiary, and I'll tell you what I mean in a minute, then you can protect that from bankruptcy, lawsuit, divorce, etc. Okay? Now, what do you need to have? You need to have this family retirement protection language in the trust. Not all of our trusts have it unless you ask for it. And it has to say, to my spouse if you're married, and then second, 1/3 to the trust created for the benefit of my daughter under the terms of my trust, 1/3 for the benefit of son number 1 under the terms of my trust, 1/3 for the benefit of son number 2 under the terms of my trust. And what that does is it allows us to do stretch planning. It allows us to take those required minimum distributions, whether the whole amount or a partial amount based on life expectancy, pull them into the trust, but not have to distribute them out to the children where they can be taken away from them. Does that make sense? So it's a whole new flavor. We used to say, and we've always said, spouse first, trust second. But we didn't break it down into these sub-trusts. Now, in order to have the benefit of that, the trust has to create a sub-trust, either a family century trust, which is an asset protection trust, or a family access trust, which is a divorce protection trust. has to have the family retirement language in the trust and has to be properly identified as the beneficiary in that retirement account.
Quick question.
Yeah.
Okay, so the IRA, my IRA, if that IRA goes straight to Scott, and he has a creditor problem, it's not protected, what happens if when I die, I have a creditor problem, and that IRA goes to Scott? Can they sue him to solve my debt problems?
At the time of your death, yes.
See, that's the reverse side of that.
Correct.
Okay.
I have a question. If the required minimum distributions are paid to the trust for the benefit of a child, and the trustee elects to postpone those distributions, again, with that language you gotta have in your trust now, and that income's held in the trust, what's the tax ramifications?
Okay. It's going to depend on the nature of the trust. Our trusts are what we call conduit trusts. So there's no tax implications at all. The money, even though the money's held, it's still taxed to the individual so that he gets the benefit of the lower tax rate.
So by the individual, you mean the beneficiary?
The
So back to me
beneficiary.
and Scott.
Right.
So if my IRA is paid to my trust for his benefit, that IRA is managed by a custodian out there somewhere.
Right.
When I die, they're required to take distributions or pay distributions. They pay it to my trustee. My trustee can take a look to see if he's safe.
Correct.
If he's safe, they can pay it to him.
Correct.
If he's not safe, they can withhold it
Correct.
until he becomes safe. The amount that the trustee withholds still has taxable consequence to him, even though he doesn't get the money.
Correct.
So if $5,000 comes in and it just sits here and does not get distributed, he would pay tax on that $5,000 at his tax rate,
Unless it's a Roth.
unless it's a Roth.
Unless it's a Roth.
Correct. Okay.
Unless it's a what?
A Roth IRA.
So here's what's really important about this. The thing that's most important to take home for you tonight is that your IRA may be subject either to your own creditors or to the creditors of your beneficiary if you leave the IRA directly to them. So if your children are named as a beneficiary and there's a creditor issue floating around out there, they may be able to go after that money by suing him.
Now, with that said, depending on how old your plan is, we make the trust the contingent beneficiary. If I did your assets in the last 5 years, and I don't know how long before I got there, and it was a married situation, I write a letter to your IRA custodian saying, leave spouse as primary, make the trust the contingent or secondary.
But I was talking to Mr. Alexander during the break, and in '99 we did his trust, and he found the letter that we sent to his IRA custodian, said, please name the spouse as the first beneficiary trust contingent. They never did it.
Okay, okay.
They made
We
the
have no
trust
way of following up with that.
primary. They made the trust primary.
Well, and we
And
just...
bypassed your spouse.
Yeah.
Well, that's not all bad.
No.
I mean, there may not be any downside to that.
Yeah.
But we ran into one last week, the exact same situation. We sent the letter saying spouse first, trust second. They just ignored it. So it still says spouse first, children second. So we didn't know that when they set up the trust. Of course, the Privacy Act, we don't get told. So now we're having to go back again to that account custodian and say, follow the instructions. And we're going to be specific, saying, instead of saying trust secondary, we're now saying 1/2 to the trust for the son, 1/2 to the trust for the daughter. So we're having to add some more specific language to that to actually follow the guidance within the law.
So let's go through this again. Let's assume that Stacy is the custodian of that investment account, where that investment account's held. She has the money, it's invested in mutual funds, stocks, bonds, whatever. If there's a required distribution, if your trust is the primary beneficiary, she will pay me, the trustee of your trust, that money. And I'll just turn right around and pay it right out to Lisbon.
Yeah, so it's not
So
a
there's
bad
probably
thing.
no
It's not a
downside
bad
to
deal.
it.
No.
Yeah.
Because she's the beneficiary of your trust.
But it'd be better to get it straightened out. Yeah.
Yeah, my
Worth
point
a
was,
look.
just
Yeah.
because we send a letter, don't assume that the institution or the custodian has it set up right. Call your custodian or your financial institution and make sure what they have on file is the way we prefer it to be.
Or if they send you the forms to
Yeah.
do it, call me
He found the
and,
original.
you know, hey, got forms, not sure, or whatever, and then I'll make sure those forms get filled out right for you.
Is
Can
there a
anyone give me-
particular benefit to have it to the trust rather than to the spouse, or a tax benefit?
No,
or a-
Well,
No.
but let me give you a reason when it does happen sometimes. It may happen, for example, in a second marriage where you have a disproportionate amount of assets and you have a big IRA. You might be okay with being sure that your spouse, your second or third wife, gets that for her life expectancy, but if she dies early, you want it to go to your kids and not hers.
Right.
Okay.
So again, all this is, everyone's situation's a separate DNA.
I have another question.
You're supposed to have the answers.
Discussion, so, anyway, if, say a spouse is a beneficiary of an IRA, okay, and the owner dies, and say that surviving spouse has qualified for Medicaid, and so she gets this IRA, is that going to disqualify her?
It's going to disqualify her from
So
benefit.
what do you do
Okay.
to circumvent that?
That's a really good question. Did everybody catch the question?
Yeah.
Okay. Because we run into this. I just had a situation not too long ago where the wife went into the nursing home and she was listed as the beneficiary of that IRA. So as soon as she went into the nursing home, we went back and we changed the beneficiary to the trust. Because within the trust itself, we have protective language that says this money doesn't have to be distributed out under certain circumstances. So we had to modify the trust a little bit to put protective language in, and we had to modify the beneficiary designation to be sure that if that money came in, it would go into the trust and not disqualify her. And it's not just as simple as saying, well, change my beneficiary, because we also have to rework the trust to deal with that eventuality.
What happens to RMDs then?
You still have them,
Still have it.
but it goes into the trust, not necessarily out to the beneficiary.
So
See,
let's go-
the beneficiary is now the
But you
trustee.
still have to figure and pay your
Yeah. So
tax on your RMD.
let's go back to the situation we just talked about. So Elizabeth is the surviving spouse. Let's assume that he leaves the trust as the primary beneficiary. Well, let's make it easy. First, if she's the primary beneficiary, custodian is going to pay straight to her based on her life expectancy. Okay? If the trust is the primary beneficiary, her life expectancy still controls, the money will just go from here to your trustee and then to her.
That's what we want.
Difference
Yeah.
kind of being is that in this situation, it doesn't really make that much difference. But in the situation he described, you want it to go to the trust instead. So again, it's like Larry always says, it's depends on your situation.
I always have questions.
And you also have answers.
Debbie?
Now, is this only on IRAs or is it also on SEPs, Roth, all that?
Any qualified retirement account.
Okay.
All the above.
All of that, okay.
Yes, sir.
Oh, that was the same question.
Okay.
Thrift savings plan.
Boy, you're good.
TSP is the same.
Yeah.
That's it.
Okay, well, that's a complicated area, but it's one that's becoming more and more important to us, and we pay a lot more attention to it than we did 15, 20 years ago.